Today at the National Press Club, President of the Law Reform Commission, Justice Mordy Bromberg, and Domestic, Family and Sexual Violence Commissioner Micaela Cronin on how the justice system and community can better address sexual violence. Mordy Bromberg and Micaela Cronin with today's Press Club address.
Hello and welcome to the National Press Club and today's Westpac address. My name's Tom Connell, I'm the President of the club and also an anchor at Sky News. Today's speakers are the Australian Law Reform Commission President, the Honourable Justice Mordy Bromberg, and Domestic, Family and Sexual Violence Commissioner Micaela Cronin. Our theme today, safe, informed and supported, addressing sexual violence. The Law Reform Commission's recently published report, Safe, Informed, Supported, Reforming Justice Responses to Sexual Violence, highlighted very much the complex challenges to achieving justice for people who do experience sexual violence. It's also a core focus of the Domestic, Family and Sexual Violence Commission and the National Plan to End Violence Against Women and Children. Justice Mordy Bromberg is President of the Australian Law Reform Commission and also a current judge of the Federal Court of Australia. Micaela Cronin, as mentioned, the Domestic, Family and Sexual Violence Commissioner. She also began her career as a social worker in family violence and sexual assault services. Please welcome our first speaker, Justice Mordy Bromberg.
Thank you, Tom. Great to be here. Can I commence by acknowledging the Ngunnawal and the Ngambri peoples as the traditional custodians on the land upon which we meet today. I pay my deep respects to their elders, past and present. I also want to extend my thanks to the National Press Club, and particularly because you're giving Micaela and I an opportunity to shine a spotlight on a social problem which is clearly out of control. Not only out of control because sexual violence is experienced in Australia in endemic proportions, but out of control in the sense that no strategy has yet effectively addressed the problem. Now, of course, there are many levers that government can pull to help address sexual violence, such as improving education, improving social services, but also improving the way the justice system deals with sexual violence. Commendably, government has begun to pull that third lever. Improving the justice system's response to sexual violence was the focus of a recently completed 12-month Australian Law Reform Commission inquiry. One of the principal findings of our inquiry, and the fundamental point I want to make today, is that the problem of sexual violence will not be addressed unless the justice system is given a better opportunity to deal with it in circumstances where currently it is not dealing with it. Why? Why is that so? Because typically sexual violence occurs in Australia without leaving a trace on the justice system. Most perpetrators are not held to account, and the vast majority of people who have experienced sexual violence are not given the opportunity of a just outcome. 9 out of 10 women who disclosed to a recent ABS survey that they had been subjected to sexual violence did not report to police. But even when victims do report, their engagement with the justice system is typically short-lived. In New South Wales, Victoria, and right here in the ACT, and likely across all states and territories, in the order of 75 to 85% of reports to police do not proceed to charge. That all suggests that only about 2% of women who say they've been subjected to sexual violence are able to overcome the barriers to access to justice. It also suggests that at best, only about 2% of those alleged to have perpetuated sexual violence are held accountable before the law. That is why the Australian Law Reform Commission says that most people who experience sexual violence in Australia shoulder that harm without an opportunity for a just outcome. And why we say that most people who perpetuate sexual violence face no consequences for their wrongdoing. This means that in our society, sexual violence is typically invisible. It is not recorded, recognised or announced. Community safety is not enhanced. The justice system, and by that I mean police, prosecutors, the legal profession and the courts, will not fix the staggering prevalence of sexual violence on its own. However, the justice system does have a critical role to play, and the problem of sexual violence cannot be addressed unless the significant failings of the justice system are rectified. Many of the barriers to engagement with the justice system for people who have experienced sexual violence are barriers for which the justice system bears some responsibility. Those barriers need to be addressed, and they are the main subject of the ALRC's report. We need to better understand that people who have experienced sexual violence need to be assisted to access the justice system and the just outcomes that the system is capable of providing. We also need to better appreciate that for our community to be safer, society needs the perpetrators of sexual violence to be brought to justice, for their conduct to be exposed, renounced and addressed, and for a message to be sent to all that sexual violence will no longer occur in Australia with impunity. Bringing people who have perpetrated sexual violence to account under the law is a fundamental requirement of a society governed by the rule of law. The Australian Law Reform Commission is government's trusted expert and independent research and advisory body on law reform, providing government with frank, fearless and expert advice for the last 50 years. It's our 50th anniversary this year. In our national inquiry into the adequacy of the justice system's response to sexual violence, the ALRC received hundreds of submissions and was greatly assisted by the insight of a lived experienced expert advisory group. We also extensively consulted with police, prosecutors, defence lawyers and judges. Frontline service providers were also consulted, as well as many academic experts. We also heard from many other people with lived experience of sexual violence and lived experience of the justice system. Those valuable contributions were then supplemented by research and the astute consideration of our talented team of law reformers, led by subject matter experts, the Honourable Marcia Neve and Judge Liesl Kadelka. Our 12-month inquiry produced a report titled Safe, Informed, Supported, Reforming Justice Responses to Sexual Violence. The report makes 64 recommendations for either reform or further inquiry. Of all of the conclusions made about the justice system's response to sexual violence, the ALRC considers under-engagement with the justice system to be the most significant problem. Most of the recommendations made in the report are directed at addressing the barriers to access and engagement with the justice system that people who have experienced sexual violence face. Now, we don't suggest that the problem of low trust and underuse of the justice system by those who have experienced sexual violence is the fault of those harmed. Nor, by focusing on that problem, have we ignored the problem that many victims of sexual violence who do engage with the justice system are subjected to more harm than good. To the contrary, the ill treatment and re-traumatisation often experienced by complainants of sexual violence who do engage with the justice system is itself one of the most significant barriers to engagement. The reason that many people who have experienced sexual violence do not engage with the justice system is their fear of ill treatment by police and prosecutors and during a trial. To address this, the ALRC has made many recommendations, including to improve education and training about trauma for police, for prosecutors, lawyers and for judges, to strengthen police and prosecution guidelines to better prevent traumatisation and the high rates of disengagement, to ensure that prohibitions on inappropriate questioning of complainants during cross-examination are properly applied and enforced, to challenge and address myths and misconceptions about sexual violence, and to provide more assistance to complainants so that they can effectively engage with the justice system by giving them access to their own legal advice and to legal representation to protect them from the unwarranted disclosure of their private and confidential information. If those failings of the justice system can be avoided or diminished, then one of the most significant causes for the under-engagement problem, the perception that if you engage with the justice system you will be re-traumatised, will itself be diminished. The ALRC's roadmap to improving the justice system otherwise addresses the under-engagement problem in three main ways. First, we tackle the current absence of a safe, informed and supportive place to report sexual violence as a pathway into the justice system. Currently, police reporting is the principal place that people who have experienced sexual violence seek access into the justice system. We know that people who experience sexual violence can feel scared, ashamed, humiliated, embarrassed. Feeling angry and betrayed and feeling powerless and unworthy can stop people who experience sexual violence from talking about what happened to them. We know that the formal disclosure of sexual violence can be a very difficult experience. To overcome this significant barrier, the ALRC found that people who have experienced sexual violence need a safe, informed and supported place to disclose. Research tells us that properly resourced frontline sexual assault service providers can provide a best practice, trusted and safe place to formally report sexual violence. These services are also well placed to connect people who have experienced sexual violence to the legal advice they desperately need. Once connected, people who have experienced sexual violence can make well-informed decisions, well-informed choices about their rights and entitlements, and to decide whether and how to engage with the justice system. The ALRC proposes, firstly, that this kind of legal assistance and advice be available to every person who has experienced sexual violence, irrespective of where they live. And secondly, that the support services of what we call a justice system navigator be provided. That is, a support person who would walk alongside and guide complainants through the criminal justice system, including by supporting them to report to police. Second, we tackle the high attrition rate. the up to 85% disengagement rate for those people who have reported to police. The 2021 inquiry held here in the Australian Capital Territory found that the predominant reason for the low charge rates in the ACT is the failure of police to properly and appropriately investigate sexual offences. The findings of that ACT review reflect what complainants of sexual violence have been saying for decades. They feel disempowered, disrespected and re-traumatised by police responses to their reports, and that they consequently withdraw. The ALRC considers the greater scrutiny and accountability of police behaviour and decision-making is required. To better understand the systemic reasons sexual violence matters typically drop out of the justice system, we've recommended that each state and territory establish a task force to review all reports of sexual violence made to police within the last 12 to 18 months. We also recommend establishing an independent review and complaints mechanism to both facilitate the ongoing review of police decision-making and enable an opportunity for complainants to challenge decisions made by police not to progress to charge. Thirdly, the ALRC considers that people who have experienced sexual violence will more likely engage with the justice system if we expand their access to justice, and in particular their access to the civil justice system, and also to restorative justice pathways and remedies. We recognise that people who have experienced sexual violence have diverse justice needs, well beyond the need to see a perpetrator convicted and imprisoned through the criminal justice system. In the context of the 1.7 million Australians who experienced sexual harassment over a recent 12-month period, just 12 months, the ALRC makes recommendations to make civil justice pathways more accessible by extending the prohibition on sexual harassment, which in practical terms is largely confined to workplaces, to all areas of public activity. Reducing financial barriers and giving expanded access to cheaper and quicker tribunal processes for dealing with sexual harassment. Shifting the burden of and responsibility for addressing sexual harassment from the individual harmed to organisations and regulatory bodies, and expanding the range of orders that can be made when a court or tribunal finds that someone has been sexually harassed. These proposals build on the very good work undertaken by the Australian Human Rights Commission's Respect at Work report. We also recommend making restorative justice pathways more accessible by legislating for restorative justice in sexual violence matters so that this pathway is more widely available. There are many, many more recommendations that we have made, but I don't have time to outline those. Some include the need for better data collection and also for better evaluation of past law reforms and evaluation of our own law reforms if they're implemented. But it's important to emphasise, and I do emphasise, that all of the ALRC's recommendations can be implemented without compromising the fundamental rights of an accused to a fair trial. Finally, may I conclude by saying that the National Plan to End Violence Against Women and Children puts the annual economic cost of gender-based violence, including sexual violence, against women and children at $26 billion. That's the annual cost. It states that more needs to be done to ensure justice systems are safe, accessible and easy for victim survivors to navigate. Doing more will require more resources and more commitment. However, the investment necessary is well justified. It far outstrips the financial and human cost of sexual violence remaining widespread, underreported, and in the words of the National Plan, in the shadows. The work of Micaela and the Domestic Family Sexual Violence Commission and the ALRC's proposed reforms will help to take Australia out of those shadows. We shine a light on both the problem and the solution. My appeal to you, the media here gathered, is that you now amplify that light into the blowtorch required to help to finally bring the problem of sexual violence under control. Thank you for listening.
Thank you for the address, Justice Bromberg. I want to join you in acknowledging that we're meeting on Ngunnawal Lamb lands today and pay my very deep respects to the communities who have cared for these lands here for many thousands of generations. I particularly want to point out too that women within those communities were keeping each other safe, and we have a great deal to learn from their traditions and their practices and Aboriginal controlled organisations, particularly in this space as well. I want to acknowledge and Justice Bromberg has talked about the input, particularly into this piece of work of lived experience advocates. We are here today having this conversation because of decades of women fighting, standing up, caring for other women, children who had experienced sexual assault, underfunded, sometimes unfunded. We are here because of your work and your advocacy, and both people with lived experience but also the learned experience of the frontline sector. And I want to acknowledge those who contributed to this work and those who are here in the room today. Thank you. It's hard work and it's difficult to... One of the things as I was preparing for this address today was spending the last couple of weeks reading the report in detail, thinking a lot. It's very hard to face this front on. And as a community, we don't face the extent in the way that Justice Bromberg has just outlined and the ALRC has outlined. We don't face it in fully face on all the time. It's too hard. And I want to acknowledge that there are people who do that every day. And it's hard work. And I thank you on behalf of the community for the work that you do. About 30 years ago, I was a 20-something-year-old young woman working in a sexual assault service. And I was, at the time, deeply shocked by the extent and prevalence of sexual violence, the lack of access to support and justice that people who had experienced sexual violence had, and, again, as the ALRC has emphasised, how little access to support and justice they actually had. That was about 30 years ago. So I'm going to talk about the definition of a generation is the time between when someone is born and when they go on to have children. So I Googled what time frame that is. I've Googled it a number of times actually, because people ask me that question because the national plan commits to ending gender-based violence in a generation. So it's about 20 to 30 years. I'm going to take a bit of artistic licence and talk about 30 years. People are having children later these days, and talk about a generation that passed, I'm going to look back a generation, and I'm going to look forward the generation that we have committed to ending gender-based violence in. The ABS, the Australian Bureau of Statistics, started their national crime collection database in the early 90s. The sexual violence database was started in 1993, the same year that I started working in a sexual assault service. So we've only been collecting data about sexual violence nationally since 1993. In that time, we have seen a 97% increase in just reported cases of sexual assault. That's nearly double in 30 years. We don't know what the trajectory was before that because we weren't collecting the data, and I really commend the ALRC for the recommendations around what we need to know and learn about in terms of what data we need to be collecting, what stories it tells us about, and where the intervention points are. So, as I was introduced, I'm the inaugural Domestic Family and Sexual Violence Commissioner. The Commission was only established 2.5 years ago, so we've got a bit of catching up to do on the Human Rights Commission and the ALRC. The Commission was established partly, we've got 4 key areas of responsibility, and in thinking about that, they're all things that we really need to be thinking about in terms of implementing both the ALRC's report, but more broadly the National Plan. The Commission was established to promote the National Plan and to promote the objective to end violence in a generation. What other objective could we possibly commit to? We have to really tackle the appalling levels and one of the things that I think the ALRC has done very well is to lay out the scale of the problem. 1 in 5 adult women over the age of 15 have been sexually abused, sexually assaulted. 1 in 16 men, 1 in 3 girls, and 1 in 7 boys. They are really shocking statistics that, again, we do not think, talk, address enough. This is absolutely, as Mordy has said, out of control and unacceptable numbers. So, from 1 in 3 girls being sexually abused, 1 in 5 women, only 9 out of 10 of those report. 75 to 85% of those. 1 out of 10. 9 in 10 don't report. 1 in 10 report. Of those 1 in 10 who report, 75 to 85% don't go on to prosecution, and far fewer than those actually is there a result. So we have a very significant problem. I'm going to talk to 3 questions. The first is the scale and scope of the problem. So I think the Commission has laid out the scale of the problem very, very well, and we need to, as a country, we need to face that. The scope of the problem is far broader than the justice system, and addressing the problem requires us to be tackling it more than just... I commend the work of the ALRC in identifying what the critical role that the justice system needs to play. However, the justice system isn't going to be able to change this on its own. And if we are not addressing it in other arenas, then also we're not going to see success in the justice system, because the justice system is made up of people who hold on to myths and prejudices that have a significant impact on the agenda and on the outcomes. The second question that I want to address is what more needs to be done. So this piece of work looks at the justice system and was given a year to do a really significant piece of work. The last chapter of the inquiry looks at the things that they were not able to tackle. We all need to pick up the mantle that the ALRC has put down, and we need to continue to take that forward. There is more work that needs to be done. The ALRC have done a good job of scoping the beginning of a roadmap, but we need to take that further, both within the justice system but more broadly, if we are going to address it. We need to be looking at our child protection system. We need to be looking at juvenile justice. We need to be looking at family law. We need to be looking at what is happening for women with a disability in institutions, in aged care, in the education system. We need to be making sure that people are safe in schools, in universities, in their workplaces, in the institutions in which they live and are cared for. For women who are incarcerated, we need to be looking at what the issues are for overrepresented populations, sex workers, migrant multicultural women. We absolutely need to recognise that Aboriginal and Torres Strait Islander women are very disproportionately impacted by sexual violence in this country, and that institutional and systemic racism impacts on that. So the ALRC does play a critical role. We do have a responsibility to think about how we can better keep our communities safe. How we can respond to people who have experienced sexual violence. But if we're going to end gender-based violence in a generation, it will take far more than the justice system to tackle that. In terms of one of the other things I wanted to talk about in terms of what more needs to be done is one of the things that the Commission has been tasked with and again has been raised in the ALRC's report, and that's improved coordination, collaboration and harmonisation across the jurisdictions. The ALRC, like the Commission, is a Commonwealth body, and many of the recommendations in the report actually are looking to what the jurisdictions need to do to step up and change at their levels. We know that frankly we have a mess of confusion and challenges across jurisdictions. We have different legislation. We don't have good information sharing across states and territories and across portfolios. We need broader engagement in this across every portfolio. I've mentioned health, education, yes, the Department of Social Service, Attorney Generals, but just about every area of our community needs to be thinking about what role they have to play in addressing the levels of sexual violence and the underreporting of those crimes. The third and last question that I want to talk to is where is there hope? Because I think it is critically important to believe that we can make change, to believe that the national plan can be effective, that all of our efforts are not going to see those graphs continue to climb. Other countries, other places, other crimes, other national challenges, we have collectively, when we really put our mind to it, we have been able to turn those curves. So we have to believe that we can change this. Hope is a muscle and it needs to be exercised. We have to believe that change is possible. So I want to finish by talking about where I think there is hope. I think the fact that the Attorney-General tasked the ALRC with this piece of work and that it has been completed and that we are having a national conversation as a result of that is hopeful. I think it's really important that we continue this national conversation and that we do, as Mordy said, take sexual violence out of the shadows. We don't talk about it enough. We don't talk about incest. We don't talk about child sexual abuse. We need to be talking about these things. So we are having a national conversation. It's squarely on the agenda and we need to keep it there. I am hopeful about one of the other things, again, that is unusual for this inquiry is the way that lived experience has been embedded in the process, that we are actively listening to people who are directly impacted, because people who are directly impacted by laws should be informing those laws. They should be informing the changes that we are making. And we need to listen to them as we implement change, because there's always unintended consequences. And data is always lag and doesn't necessarily shine a light on what is happening now. So the fact that the ALRC was informed by the expert advisory group, that group of experts by lived experience has been extended by the Attorney-Generals really gives me hope. And the Commission has established the first National Lived Experience Advisory Council.